Okay, right now. Here we are 25. Okay, shall we go at the end? Because also Giovanni De Gregorio is with us. Yes, ciao Giovanni.
Yes.
Yes, I see you. Okay, wonderful. Okay, let me say many thank you, first of all, to the Associazione Italiana of Diritto Comparato and the Italian Association of Comparative Law, and the American Society of Comparative Law, the Young Comparatives Committee in particular, for these wonderful seminars. And the seminar of today is devoted to this great topic, really great topic, new technologies, public law issues. We are discussing at the end of the frontiers of the public law, and we are discussing regarding the techniques of the treatment, I would say, of the uncertainty. At the end, new technologies and law have a very precise grammar and syntax, if you want to follow the grammar and the syntax. So there are several and very relevant elements and factors between the new technologies and the law, especially the public, but also yesterday there was a wonderful seminar on the private law. So we now discuss about the new technology and the topics of the public law, following several different things and several different topics. For instance, the legal and social consequences of the artificial intelligence, the big data, virtual and blockchain coins, robotic justice, and so on and so on. Today, we discuss with 5 young great scholars, Tommaso Amico di MEANE, Giovanni De Gregorio, Giulia FORMICI, Claudia MARCHESE, and Davide ZECCA, of several these topics on the new technologies. Each participants each speakers have 20 minutes. Please discuss in English if you want, if you are comfortable with the English language, and I will follow the path outlined in the program. So the first one is Tommaso Amico di MEANE from University of Milan, and the second one is Giovanni De Gregorio. 20 minutes each one, and then we have a Q&A all together discussing about your topics. Thank you so much. We can start right now. Tommaso Amico di MEANE, you have the floor, or the web, I would say.
Very much, Professor Clementi.
Thank you.
Introduction. Okay, then I will switch my speech in English. Can you all hear me well?
Maybe up is better, if you can.
Okay.
Okay, wonderful.
Okay, perfect. So what I would like to bring on this virtual table is a reflection, although a little bit rough, about constitutionalism in algorithmic democracy. I have been somehow taken from this unexpected enthusiasm from a legal scholar about technology that over the last 10, 15 years, I would say, brought to the field many new publications, group of studies, as long as journals. I was checking on ESSN.org just before, and I found 176 journals with technology, about technology and law, 91 from the United States of America. And most of them born basically over the last 10, 15 years. So there is a lot going on, and all this as a kind of inputs on redrawing our, let's say, formative often in the universities, but also our pedagogical tools. And this was true even before the COVID-19. So now is even more on the table, this aspect. And this enthusiasm, I was saying that is quite unexpected because it's a kind of contrasting with the traditional, disease of the legal scholars for technology. Of course, we have here in Italy some pioneer like Professor Lozano, Rodotà, Frosini itself, that over the 70s basically has traced a line that we, after years, we fully understand perhaps right now. And what I see within this framework, current framework, is a change of paradigm. I'm quoting the Luciano Floridi analysis, talking about the revolution that we are basically experiencing. And the difference from the past in the society of information is that we are not anymore just able to record and transmit information, but rather to process information. And this is the algorithm, by the way. And this change toward the algorithmic society is kind of with no return. I mean, quoting Professor Oreste Pollicino that is here, we cannot go back from the bit to the atom anymore. So it's a kind of evolutionary state. And all this leads me to share, first of all, I would say a methodological reflection, theory and technique. Science, I mean, there is a kind of transversal understanding and exchange between subjects in a kind of Renaissance flavor, I would say. So the multidisciplinarity is there, and this is a kind of necessary and important characteristic of our today's project. I must confess that I read many papers written by legal scholars on algorithms, but I believe that I fully understand what an algorithm is just when I was talking with a professor and a maths professor from Pisa University, and it took 10 minutes to explain me perfectly what an algorithm is. Of course, this change of paradigm brings opportunity and risks. Opportunity, of course, the artificial intelligence. I mean, the possibility, for example, to contrast and to see, from case law, 100 case law, and to put together and find some commonalities on jobs that takes for a human being take, of course, hours and days, and now we can do it with a click. But of course, we have also some risk. And I see, of course, there is all the predictive justice. There are many bias in the algorithmic logic itself. And we know that that decision also cannot necessarily be objective, okay? And this is something that we are, again, experiences. Within this field, I see some specific challenges and warning for comparative lawyer and opportunity, of course. Because when we are processing information, the technology and algorithms basically end up with the number, usually, okay? So, and we as comparative lawyer, we have traditionally a problem with number. There's an interesting article by Ralph Michaels about the silence of traditional comparative law with number, an article from the American Journal of Comparative Law. So there's a sort of disease in the sense of, well, if it's about number, it's not our job. We are comparative lawyers, so it's not something that You know, and of course, that article was about the doing business report and what the lacking of the comparative lawyer voice within this debate. And I see Professor Soma, of course, who is someone that did not accept the silence about the doing business reports. Okay, so this is an answer also to Ralph Michael. So once we end up with number, is a kind of instinct to compare number, of course. And what comes to my mind is, for example, the European Commission publication on EU Justice Scoreboard, rather than all this debate about the rule of law. So what comparative lawyers have to say on when we are seeing, for example, a comparison on, you know, in the independence of justice, saying that Romania scored 83 points and Italy 56. Okay, those are aspects, and so I believe that it is important. It would be important and challenging for comparative law to raise a voice, because of course Brussels is not waiting for academics in order to do a comparison. So there is still, let's say, a gap that could be filled up with the ages of experiences and the debate in the academic sector, and notably on comparative law. This, in the field of opportunities, I see also a debate, the possibility to spend some time thinking about more generally the relation between man and technology, which is, of course, is an ancient debate from you know, I pop up into my mind the first images of Kubrick, Odyssey in the space. So that the first scene where there's the monkey using that technology to change the awareness of change, of be a active part of a change, and to use that technology. And the conclusion they usually raise at the end of this debate is that, of course, technology cannot fully substitute the man, of course. And this is something also that we saw in the Italian case law, you know, the sentence of algoritmo, April 2019. So to have more human decisions, so there must be a control by human. The human should control the algorithm. And of course, this kind of question could easily go through some existential issues, and is not a case that one of the main reflection and field in the technology and law field, it comes from philosophy, the philosophy, law and philosophy, basically. And this would be also a possibility, I would say, to rethink our rational ambition, and as legal scholar to have again a rational national decision, a rational way of understand the reality. So this kind of exercise could be somewhat therapeutical for us as legal scholars. And here the point about the theoretical challenge that suggested also the title of my presentation. Again, I'm quoting Oreste Pollicino. So the traditional constitutionalism, of course, has to deal with public power. okay? Rather, the the constitutionalism 2.0 put it at the center of the reflection private actors, basically. Among the 100 economic realities more relevant in the world, now we have more private companies than states. But in my view, the most interesting part of this reflection is not the quantitative part, rather the qualitative part. That is to say, what is interesting is the way the private actors are organizing themselves, are organizing the power, is quite similar to some aspects that are typical of the modern state. Let's do an example. Facebook. Facebook has a population, virtual, although virtual, but a population and a specific territory, okay? A territory without proper borders, but indeed is a territory. And then the Facebook again kind of exercise sovereignty, a technological sovereignty. So we have people, we have territory, we have sovereignty. So the main ingredients of modern state. And again, about the ambition of Facebook, we can see, for example, to have a proper money, to have a proper value, to have a court that can judge and sanction the violation of fake news or whatever. They have the kind of ambassador called country managers, but that in the end are in charge of negotiating their parallel orders with other states, like public states and non-private states. I was quite impressed and stuck reading. It was about during the breed selection in the UK, and there was an interview by Mark Zuckerberg who say, "I will try to do my best in order to guarantee an integrity of UK election." That is kind of weird as declaration. It's a kind of independence declaration, and that led me to reflect about this, the very nature of this other Leviathan, as I call it. Compared to the past, of course, it's not new to have this contrast between public powers on technology. I was thinking about the United States of America, a Soviet Union. Let's think about the space mission or whatever. What is interesting to note right now is that this kind of contrast, this kind of challenges can come up using the technology, and the actors of this specific dynamics are not just public actors, are not just private actors, but even single person. Okay, and this is quite impressive to think about that. For example, a ransomware attack can be led from a 15 years old boy in his room. This is something that we should reflect about, considering that the technology that we do have now in, for example, in an iPad, first generation iPad, as something that 50 years ago was something that it was could be available of a small medium state, okay, in terms of to buy that kind of technology. And this could be very frustrating from a state point of view, because of course the state cannot guarantee anymore, not necessarily guarantee its citizens. And what jumped into my mind is change of opinion between Ocasio-Cortez and Zuckerberg in the United States Senate. And what is frustrating is also the role of the citizen itself, of course, because sometimes the citizen basically don't trust anymore the state, and they found their own way to protect themselves from the amount of technology that we are surrounded, basically. And the last option is, of course, when the two leviathans go together, and I'm thinking about the so-called digital authoritarianism, of course, thinking about some countries, not just China in Asia, but also the control system that we are witnessing in Singapore, Vietnam, Cambodia, and all this also should be considered. All this, and I end up here this short presentation to say that the impression is that the national state basically is more often right now find a kind of challenge with some private states. I don't know if they are proper leviathans, and that more or less consciously are following some of the path that the traditional state left on the floor. And within this framework, so how can we limit this new type of leviathan? Of course, how the social pact between the leviathan and the people is celebrated. Is enough a click, and of course we have here all the GDPR issue and so on. And most notably, from an academic point of view, which are the categories that we as legal scholars have to use in order to describe the consistencies of this new type of power? Are the same categories of the traditional constitutionalism, or we do have to consider to change it, to bring some rethinking also in this field? Of course, we are witnessing something which is also beyond the definition. Is not just question of classification, and what is changing right under our feet are the object of our study themselves, the form of state. So think about what is going on right now, using how the technology can change the relations between power and people, from the Arab Springs to what we saw a few months ago in Egypt, starting from a video from Spain on YouTube, and what is also happening right now from Minneapolis to Canada, Israel, with all this huge mobilization that basically yes, and I'm concluding. All this mobilization that found in the social network extraordinary tool in order to spread it. So the technology, and here I really end, doesn't ask for produce change. So our role would be, in my perspective, to continue to observe and to find a meaning, also theoretical meaning, of what is going on, and to raise the voice of comparative law on this subject that basically are the subject where our academic fathers basically deal with. And I believe that also this kind of event and this panel with my colleagues could bring a small sign in this direction. Thank you very much.
Thank you so much, Tommaso, Tommaso amico di MEANE from Bocconi University of Milan. The title of the topic, It's My Fault, is Rethinking Leviathan, the challenges of the constitutionalism and the comparative law in the algorithmic age. Thank you, Tommaso. Now we have Giovanni De Gregorio from the University of Milano-Bicocca, and the topic is Content Moderation, a comparative constitutional law analysis of the US and the EU approaches. Giovanni, you have 20 minutes.
Thank you so much. Can I ask just a very quick question if I can use slides, otherwise I can present even, you know.
For me, without any
If you
problem.
can use slides, just keep in mind that the real Donald is listening to you.
Yeah,
so
but it's great actually. So we can propose something.
So just moderate your terms before he moderates you.
Okay, I will try to share my screen.
Yes, thank you.
Let me see. Okay.
Down.
Okay, guys, can you see it?
Wonderful.
The presentation. Okay, amazing.
Okay, go.
So first of all, thank you so much. It is my pleasure to be here and discussing with you actually this topic that is quite critical for not only for the protection of freedom of expression, but also for democratic values. And first of all, I should also thank Tommaso for introducing a lot of topics that will allow me to, you know, kind of building a bridge between my presentation and this presentation. And so this is actually great. So, but let's see what is what this presentation will be about. This actually will be the agenda of today that I will try to deal with in 20 minutes. And actually we'll focus firstly on what are the constitutional origin of content moderation. And as we'll see, we'll move from the US framework to the EU framework. And we'll start to understand this kind of legal transplant and then cross-fertilization, how did it work 20 years ago, almost 20 years ago. Then we'll start before to deal with the comparative perspective between the two constitutional approaches. We'll look at what we call, what usually scholars call the logic of moderation. So just to understand what is behind the screens when social media, of course, decide to moderate content and how they moderate content, and especially what is a notion or a definition of content moderation. Then, as I already told you, we will deal with the constitution, actually the constitutional analysis of the two approaches across the Atlantic. And at the very end, we'll just try to, in some way, underline what are the dilemmas and the road ahead when we focus on content moderation across the Atlantic. So first of all, the first question, as usually, it's a question of just to understand and frame the topic of content moderation. First of all, of course, one of the main topics is the definition of content moderation. And I think that we can use at least these three categories, that is the distinction between soft and hard moderation. So if you have the idea that content moderation actually is an editorial decision according to which we'll go back, according to which platform decide how to organize content, but also how to remove content, or also how to maintain content online when they do not infringe their terms of services. So on the one hand, we have the process of soft moderation. This is quite important because it's what happens actually behind our newsfeed on Facebook, our results of the search engine, but it's not actually concerned the removal of content, but actually the organization is what actually is filtered, what is hidden in filter bubbles, or what is hidden online by algorithms, like Frank Pasquale said in his book. Actually, on the opposite, the hard moderation, or complementing rather than the opposite, the hard moderation is the process actually of removal of content and all the process that concern redress mechanisms, transparency concerning the removal or the maintenance of content. Second of all, it is important to stress that we have at least two categories of moderation. This is the community moderation, like a moderation that we have with the web forum, where me with some of my friends, we have a forum and I decide to moderate that outside any commercial scope. Here we are dealing with commercial content moderation. And this is a big challenge, is a big difference, because when we deal with commercial content moderation, we are dealing with something that is made for profits. And then we'll see what is the logic of moderation behind commercial content moderation. And then the last point is the distinction between human and automated moderation, because we know very well that moderation is not something new. Also, traditional media outlets have dealt in the history with, of course, moderation, and still with they deal with moderation. But we should distinguish between human and automated moderation. And I refer, of course, to algorithms and artificial intelligence technologies implemented within the framework of social media. But especially another point to stress is that in this case, there should be a tertium genus that concern the mix between human and automated, because usually content moderation occurs in the mix, actually at the intersection between human moderation and automated moderation. So first of all, before still to focus on content moderation, before I mentioned that usually content moderation is something that is not entirely new, because we have seen actually how also traditional media outlets moderate content when they decide what content they publish, what is the schedule, and so forth. But actually, when we focus on social media, I think there are at least these three differences. Of course, these are not exhaustive, but at least they provide you some insight to understand what are the differences. First of all, geography. Okay, probably we can consider there are also cable TV companies also broadcasting globally, but at least the global scale of social media platform activities, it's broad. And this is what Tommaso said, actually, that they have usually also 3 billion of users. So it's not just like, you know, a traditional media outlet when we focus on a matter of quantity. Then, of course, liability. When we deal with content providers like broadcasters or traditional media outlets, newspapers, we are dealing with the responsibility going directly, you know, primarily on the subject that publish content. Here with social media, we are dealing with as we know very well, with a framework of secondary liability. And thirdly, the management of content or the moderation of content, usually when you look at traditional media outlets in the history, has been actually quite human, you know, because they are human, they decide what content should be published, where, which side, in which parts of the newspaper, on which side of the hour for television. Here we are dealing with systems that are, especially in the phase of soft moderation, are organized entirely and often just by machine. So this is quite important to focus on this difference, because when we look at the origin of content moderation, we should look, and here we'll start a little bit to look at the comparative perspective. We should look at the US framework, and we know how the Communication Decency Act that now, you know, with the executive order of the President Trump actually came back, actually shed the light on the issue of this rule after 25 years almost. And we see that the idea of the Communication Decency Act was to exempt online intermediaries and computer services because, of course, there were already cases in the 90s that shown actually that they would have been liable for many content they host. And so the idea, in order to ensure the development of digital services and, of course, the freedom of expression, also these actors, the idea of the Congress at the end of the century was just to immunize these actors, but also, and this is because the immunity is the first part of the Section 230, but the second part is to provide the Good Samaritan rule. That is actually the constitutional foundation of content moderation, because immunize platforms and allow platforms to deal and remove objectionable content. So actually the mix of immunity and the Good Samaritan rule is why actually we are dealing with content moderation nowadays. And the same actually, even with some differences, was with the Digital Millennium Copyright Act in 1997. Actually, even if the Digital Millennium Copyright Act introduced the mechanism of the notice and takedown. So it's not just an immunity, but an exception of liability according to specific conditions. When we look at Europe, we can see that in 2000, actually, and this is the very first part of the comparative perspective of this presentation, we can see still, if we look at even the recitals of the directive, that the aim of the directive, the goal of the directive is still to ensure freedom of expression, while the difference is that the directive adopted the system of the DMCA. So it's more close to the DMCA rather than the Communication Decency Act. But what is interesting to see is that how Europe actually took a rule coming from the other side of the Atlantic and actually implemented it in its legal framework. And we can see, actually, this is quite relevant, because when we see, for example, and we'll analyze once again this point at the end of this presentation, the Commerce Directive does not just provide safeguards in the process of moderation. And in some way, this was the original constitutional sin of the European framework, just to adopt something coming from another constitutional umbrella that was that of First Amendment. And so this legal transplant is quite interesting because in some way shows you how sometimes putting something coming from a different constitutional tradition within another kind of constitutional legal framework can produce different effects and two divergent paths, as we have experienced in the last 20 years when we look at the US and Europe. So, but basically, even in the 90s, even in Europe, the public interest at stake was actually the tackling of course, of objectionable content, because no one wanted the digital environment become plenty of fake news or disinformation or hate speech or other objectionable content, unauthorized copyright material. But at the same time, there is the interest to ensure the right to freedom of expression, not only of users, but also of platforms that in Europe probably should be in some way looked at the idea of to protect the freedom to conduct business. But the fact is that these are public interests. What happens when we look at the private interest of the platform in content moderation? And this is why we are entering after, let's say, the origin of content moderation. Now we are entering, let's say, in the idea of the logic of moderation. So the private interest in moderation. And actually we can say that the purposes of the platform are much different when we look at the public purposes of protecting free speech online. Indeed, if we look, for example, at the logic of moderation, we can see how the social media usually are interested. Sorry, this is just, this is very short, but it's just to understand what is the main point at issue, because I have no time to talk about that. But the idea is that the social media are interested, of course, to ensure a peaceful environment online. So to moderate content, because they know that if they ensure a peaceful environment online, so without hate speech or disinformation, users will not try to escape to another platform. And this is important because users actually provide the content that then feed the advertising revenues that, of course, means profits for the platform. So the idea is that more users means more content, and so this more content means also more data and thus more advertising revenues. So if you think about it, it's the idea, of course, platforms are not neutral. They moderate content just to profit from advertising revenues. They do not really much care about whether the removal of a content, the moderation of a content is not plural or does not respect the right to freedom of expression. Because of course the idea is creating engagement and collecting data and selling those data for advertising windows. And so in some way the process of moderation, but this is not just my idea, also of a lot of scholars, is not publicly driven, but it's motivated in some way by private business purposes. And this is the first clash of also what Tommaso said before, you know, between the idea of private interest and public interest competing between each other, you know? And second of all, this is why when we look at from a constitutional law perspective, we can say, and this is something that I try to argue in different papers, is that in some way we can look at the shift from the economic freedom that this platform enjoy to a form of private power concerning of delegated powers. Like, for example, when the Communication Decency Act allowed platforms actually to moderate objectionable content, and in some way deciding, you know, what is the degree of protection of freedom of expression online, but also autonomous powers. Autonomous powers consisting in deciding what are the criteria of their community guidelines, how to enforce them, and how to balance fundamental rights online. And again, once again, just to connect to what Tommaso said before, this is the idea of actually of the power that usually are vested in public authorities. And this is quite interesting. So the question is, if users are subject, you know, to a form of private governance of expression, but also data, or private governance of our fundamental rights, of our daily lives, the question from a constitutional law perspective is, what are the safeguards users can rely in a democratic digital environment? So the idea is that how to inject public values within the private governance of fundamental rights, and in this case of content moderation of freedom of expression. And so guys, now looking at the two sides of the Atlantic, having provided this this brief introduction, sorry, but in 20 minutes I cannot do better than that. The idea is that when we
look at, you have 8 minutes, then okay, you can breathe.
Thank you so much. When we look on the western side of the Atlantic, we can say that we can see that there is an omissive approach, because since the adoption of the Communication Decency Act and the Digital Millennium Copyright Act, we do not actually had any kind of new legislative amendment or new legislative proposals to amend, apart from the Sesta Fosta Act that is actually concern the sex trafficking and specific content. There have been some bills and proposals like the Honest Ads Act, but actually there has not been any kind of idea to amend platform liability and the framework of content moderation. And this is why also a little bit, because the First Amendment is almost a constitutional shield, you know, protecting platform. And we have seen how the Supreme Court actually dealt with that when actually since the Abrams versus United States and the Buckingham versus North Carolina case, that are actually, once again, a way to express the idea that the First Amendment still should be protected in any regulation of the vast democratic forms of the internet, quoting, of course, the sentence of this case from Justice Kennedy. Is interesting that in order to regulate this kind of regulation are subject to strict scrutiny under the First Amendment. So it's not quite easy to regulate platforms, especially to regulate the way in which platforms moderate content and not the procedure. And indeed, and this is probably also Davide ZECCA can help me on this case, because he has written on this case. At the end of 2019, the court actually expressed its idea of the limit of the state action doctrine concerning private actors. Some scholars thought that this decision could open the door towards extending the state action doctrine to social media, but actually this actually did not happen. And we've seen the effect of this decision in the PragerU case, where we have seen how also federal courts apply the standards and limit the extension of state action doctrine, for example, to YouTube when removing content. And the same now, we can talk also, I have no time to enter into the debate of the executive order, but this is actually the only step that actually recognized the relevance of the communications of Section 230. And even if there was not the right mean to intervene on this section, actually the idea is that probably if you look at the legislative inertia of the Congress and the approach of the US Supreme Court, probably it was the only way to, you know, to in some way advance this kind of discussion concerning platform liability when they moderate content, and especially disinformation. When we look on the eastern side of the Atlantic, we can see an opposite path. We can see a shift from economic freedoms, so from the idea of the Commerce Directive, to fundamental rights. And this was thanks especially to the emergence of the Charter of Fundamental Rights, also thanks to all the case law and the story coming from the European Convention on Human Rights, and also the judicial activism of the ICJ in the very famous decision where we have seen the relevance of fundamental rights in digital matters. And when we look now at the digital single market strategy, that is actually the basis for the new Digital Services Act, we can see that now it is not more enough just to ensure immunity to these actors, because we should start to think about how these actors could be more responsible, could be more accountable, and how they can ensure transparency and fairness when they moderate content, because actually their activities implies, like has been said by the European Commission, wider responsibility. So, and the idea is that when we look at the European framework, we can see a new season for content and expression on a mix, based on a mix on hard and self-regulation. And the idea is that it's not enough. We are not caring about regulating content. We are more interested to regulate the process in which content are moderated. And so this is the difference from the European approach. And this is a proactive approach rather than the approach of the US that actually still deal with the protection of the First Amendment. And now probably we will deal with the Digital Services Act, and we'll try to understand in the next year what will be the next steps in the regulation of content moderation from the eastern side of the Atlantic. And so once again, in some way, this is actually what we are going on. We are going on to understand what should be the rights of the user in the face of notice, in the face of decision-making when it is made, of course, by AI technologies, but also the face of redress mechanisms. So when user can ask platform to revise their privacy decision just to come up with another assessment of that specific content. And so this is what the shift from an economic framework to procedural and substantive rights. And actually, when we look also at the GDPR, we can see this kind of convergence between data and content. And so this is also because of the GDPR in some way that has been influenced also the regulation and the proceduralization, the idea of due process and the rule of law in the field of the moderation of freedom of expression online. And so this is just a slide to say private actors are not the only problem online. It is true that especially this new season, as we have tried to define as the digital constitutionalism, focus on the threats coming from private actors, but especially in democratic countries. We should not forget that, for example, talking about internet shutdowns around the world, internet censorship is still a big problem, especially in authoritarian countries. So the idea and the challenges for the digital environment and content is not just about coming from private actors, but also from states. This is quite important to stress at the end. And so the road ahead, just to close this presentation, is that we have still the broad framework, and we would say this is the road ahead in a comparative perspective. On the one hand, we have the debate about hard regulation versus self-regulation, that in some ways the approach that links the European approach with the US one. In the second point, we have the point of accountability versus liability. So we need to make platforms more accountable, or should we change the rules governing their immunity from liability? And second of all, and generally, there is the balance between fundamental rights and innovation that could be the balance between fundamental rights or digital constitutionalism and digital capitalism. So at the very end, the conclusion of this presentation could be, of course, we have seen the US origins of content moderation and the constitutional developments in Europe. We have seen two different approaches that in some way are continuously diverging in the algorithmic society. And so the road ahead in some ways is going towards transparency and accountability. And so the question is that if we are going towards a new phase of what I've tried to call in one of my work, the rise of digital constitutionalism in the European Union. So with this, I think that I've closed my presentation. Thank you so much for listening to me. And I really enjoy your question during the Q&A. Thank you.
Thank you, Giovanni. Thank you also for respecting the time. Well, I have to say that we have already a question from Professor Somma. So, according to the first rules that Professor Zeno Zenkovic told us before, I only want to know if Professor Zeno tells me if we have a Q&A at the end, collecting all the questions, or you want to discuss each paper?
Yes, I would have the question and answer session now, and I would having the advantage of Professor K here.
Yeah.
We are all Europeans, and we're looking at the US. We study the US and so on. But maybe if we have the we have it from the horse's mouth, maybe it's very interesting. So I would, if I may suggest and somehow invite Professor K to comment on these first papers, and especially the second one that went in depth in the US constitutional decisions. So, but now, question and answers now. Okay,
wonderful. Yes, if Professor K, it's okay. We have Professor Somma because he raised the hand, and Professor K.
Sure.
Right. Professor K.
You want me to start?
Yeah. Thank you, because Professor Somma has just give you the
raised
floor.
his hand first. But,
thank you.
but these were really interesting papers, with lots of different avenues one could pursue. If I'm here as an expert on United States constitutional law, I would say that one thing that's shown by both of these is the erosion of the public-private distinction. There's a certain inevitability about it, even if things are moving sort of at different speeds in different jurisdictions. My expectation is that there's more resistance to that in the United States than there would be in European jurisdictions. Just a smaller point, but something that De Gregorio mentioned about the president's executive order about social media. I don't know how, you've probably read it, but it's the expression we use over here, I don't know if it's gotten across the Atlantic, is a nothing burger. Heard that? Which is something which has a lot of fluff, but in fact doesn't mean anything. And that was certainly the case with this executive order. Changed nothing. So that it was just kind of a, it also was kind of a spasm of the president to react to his own tweets being regulated. Well, let me mention one other thing, which is a more serious point. In the paper presented by Mr. AMICO de MEANE, the different, it reminded me, and something you might want to think about, that the national state, that is a contiguous territory with one government controlling it, is a pretty recent event in human history. So that for the prominence of that form of social organization seems to me to only really come into its own around the 18th century. And the idea that territorial division of authority is the supreme authority was certainly not true before that time. You have all kinds of other forms of social organization. You have the church, you have guilds. Today we have unions. And so I think certainly he's right that in fact the state is again under attack. But it would be a good idea to think of this kind of in the long run of history as simply moving back to the kind of more divided situation that we had earlier in our history. There are other things I could say, but I'm not going to take up any more time, especially since I jumped ahead of Professor Somma.
Thank you so much. Thank you so much. Alessandro, Professor Somma.
Thank you. I really appreciated both speeches, above all because they address the role of us as law scholars. Tommaso mentioned the idea of questioning rationality, of course, but I would say also to put at the center of our reflections the idea of power, because what we are dealing with is in fact with mainly private but also public powers, which act in a period where the state is dissolving, and the state is has been for a long time maybe the only counterpower able to control these developing powers. And of course, the idea of territorial division, as has been said by Richard Kay, is relative new or relative not widespread in human history, but it is in any case an artificial construct. But I would say also the idea of an undivided territory is an artificial construct. The state with limited powers or with limited action in economics, in politics, is linked to a very specific ideology. It is not just a natural development linked to the fact that the technological development has made the presence of the state something which is vanishing. It is linked to ideology, it is linked to neoliberalism, it is linked to the idea that hard law is bad and soft law is good, that government is bad, that governance is good. And what is wrong to me, above all, is the idea that in a neoliberal world, the state has no power and no tasks to fulfill, because neoliberalism and market, self-regulating markets, they do not function if the state has no tasks to display. So to come back to the idea that all this is challenging our task as scholars, maybe we can rediscover the old tools of the last century, which were used by the state in order to bring power under democratic control, not a control which is without adjectives. I mean a democratic control based on democratic participation. And above all, to recognize that the state is a political construction which has a political function, and we must reflect on the way how to redirect the political functions of the state, but thinking that we do not move ourselves in an ambiente with natural facts. It is everything, I would say, is artificial, and we have therefore space for political construction, and we have space for we as scholars to engage in one or another solution. Thank you.
Thank you so much, Alessandro. And there are other questions. Davide ZECCA, I've seen right now. Davide.
If I may, thank you. So since Giovanni mentioned me before, I wanted to ask him a question, and it is concerning the PragerU case of content moderation on YouTube. So in this case, the Supreme Court seems to stick consistently with its history to the state action doctrine, and therefore basically protects the freedom of speech of the intermediary, so the private enterprise. But isn't it a little bit of a conundrum today that we are facing? Because by doing so, actually, we are a little bit, at least in my opinion and in my view, denying the freedom of speech of the users of the service, especially when we consider that either Twitter or YouTube or Facebook exercise a sort of monopoly in their respective area of business, and therefore I'm not sure that, as the court held in the PragerU case, that they do not perform tasks that were traditionally carried out by the state, which is the other test that can defy the state action. So I'm just willing to hear your opinion on the possible developments or way out of this conundrum, and also if Professor K has any suggestion on this, because I know that, of course, the Drittwirkung in the US is a sort of a thorny topic, but nonetheless, I see it like something that sooner or later will have to be approached. Thank you.
Thank you, David. There is a suggestion on the chat from Professor Zeno Zenkovic. Seeing Knight's First Amendment Institute versus Trump, and there is someone else with questions, or there is a possibility for Tommaso, Amico di Meane, and Giovanni De Gregorio to respond. Okay, Tommaso or Amico di Meane want to do.
Yeah.
Okay, please.
Thank you very much, both Professor K and Professor Soma. I see the point of Professor K, and indeed what I had in mind was let's say the nation-state model. So the Western or even more European is not. Perchance that I mentioned also the Leviathan and Thomas Hobbes as a theoretical framework somehow, and in my opinion, this understanding of the state is still very present in citizenship, in our politicians, as we know, and not secondary in academia and in a legal scholar. So there's a very positivistic, let's say, understanding of the law, of the mission of the state is very there. So, and it's part of the resistance that we see and modify basically the borders of and the roles also of the state, as Professor Soma mentioned. And here we have basically we have two options. We have the option of Nico Krish, the post-national scenario, so to overcome the state, as we know, or of course the other option that would be to modify, to adapt the state to these new challenges and to the liquidity of this scenario. And the competitors, they are basically growing, and of course, you know, I would be more interested in speculate on that second option. But again, the very framework is the one of the national state that, in my view, I'm not an particularly expert in the US of the US jurisdiction, but at least in Europe, I feel that is still very, very there.
Thank you, Tommaso. Giovanni De Gregorio, you want to say something?
Yeah, thanks. Very briefly, just to put together what has been said so far. Actually, yes, as Professor Kay underlined, the idea is that the public-private divide will be increasingly fading away. And so the idea is that how we want to, if we want to protect that, or we want to go beyond this idea. To protect that, there are different ideas, because as Professor Soma also says, the idea is that coming also from the neoliberalism idea of the 90s, of the idea of freedom of speech, the idea that these actors and tech giants have been actually free to decide and how differently from other businesses. Thinking about environmental law, for example, that highly regulates companies. Why we didn't have regulation for social media? But this comes from a narrative or a rhetoric coming from the need to protect and exercise and develop, but also from the kind of invisible handshake between the government sometimes and the platform, especially after 2001. But this is just some very, very small remarks, because I don't want to lose time for the others. But the idea, in my opinion, to create that kind of bridge between the public sector and the private sector is to think also quoting also Professor Pollicino, also Tommaso mentioned him, this here with us, is also to think about new substantive and procedural rights, but also about the horizontal application of fundamental rights that, of course, in Europe is more familiar, you know, to our constitutional tradition, but probably with a different set, also in the US Supreme Court composition, probably this could be open towards a new framework, since the decision in Manhattan versus Halleck was a decision 5 out of 4. So it was contentious. So there is still open windows to go beyond the idea, but maintaining the idea of public and private.
Thank you, Giovanni. Very clear. Okay, now if there are no other questions, we can go on. And the moment is to heard Giulia Formici from the University of Milan. The topic is the use of facial recognition technologies by public authorities, fundamental rights consideration from a comparative perspective. Giulia, the floor is yours.
Thank you. Thank you, Professor Clementi. And first, can you hear me clearly?
Now you should speak louder.
Louder, yeah, thank you.
Okay. First of all, I want to join my colleagues in thanking both the Italian Association of Comparative Law and the American Society of Comparative Law, as well as all the organizers for having transposed the Perugia conference into these webinars, allowing us to present our research, notwithstanding the particular moment. And connected to this, when I was thinking about how to organize my presentation, I exactly started from this very simple point. One of the things this pandemic underlined is the key role played by technology. As said before, without technology, we wouldn't be able to be here today. And technology allowed us during this period to enjoy our rights, for example, to access to education, because universities and schools continued with some difficulties, as Professor Zenkovic said before, but we continued to do our job, and also guarantee access to public services, for example, and allowed also public authorities to control the effective compliance to lockdown rules, for example, with the use of drones. Nonetheless, the great debate that we have experienced in the last month here in Italy, for example, about the development of the contact tracing app MEANE, and the serious impact on fundamental rights deriving from the so-called digital divide, so the gap created between the possibility to use digital devices or not, allow us to clearly see the whole picture. Technology is for sure an essential instrument, but it can also raise profound questions, as my colleague said before, and significantly affect not only fundamental rights, but also the very democratic basis of our society. And in this context, I think that facial recognition is a perfect example. And in this presentation, I will try to give an overview of the multiple legal challenges linked to this technology through two different examples. So analyzing two different purposes and aims and uses of this technology. One, the more known, which is the use of facial recognition by public authorities for security purposes. And the second one, which is less explored, is the use by public authorities in order to identify users and to allow the access to public services. And just a few words about facial recognition, about what it is and how it works. It is a technology that makes it possible to compare digital facial images. There are different categories of facial recognition, but the most used one and improved one is the so-called live facial recognition. And it allows a one-to-many match, and usually consists in an algorithmic comparison between an image, so biometric data, obtained from video cameras, and images stored in a database, so the so-called watch list. And through the use of artificial intelligence technique, biometric data are processed by creating a biometric template to detect the facial features, which are used to identify basically whether the person on the video and the image on the database match. In general, facial recognition systems have been criticized, and this is a necessary premise, also by the scientific community for the quite high error rate, and also for the possibility to be biased, as some colleagues said before me, especially with reference to specific categories of the population, such as Black people or women or Asian people. Nonetheless, these systems are more and more used in the European continent, and my research is focused on the European context. Even if for sure in China it is a technology which is more extensively used. Starting with the first example, so the use of facial recognition technology for security purposes by law enforcement authorities. One of the most relevant examples in the European continent is the facial recognition system used by South Wales Police in the UK. Because for the first time, not only in the UK, but in the whole world, judges, in this case, High Court Cardiff Division, were called to evaluate the legitimacy of this system. And this important decision, which starts with significant words, in my opinion, I quote, "The algorithms of the law must keep pace with new and emerging technologies." At the end of the decision, the judges recognized the legitimacy of this system based on basically 4 considerations. First of all, because this technique was used only for large public events, because people were informed both prior and during the event about the use of this technology, and also because the bias was considered to be mitigated by a mandatory human operator check, and most importantly, because the biometric data collected by the cameras were not retained, but on the contrary, were immediately deleted if no match was found. What this decision lacks, according to the claimant position, but also academics, NGOs, and experts in this field, was the fact that the searching and matching operations were not limited to what's strictly necessary, because the evaluation, collection, and access to all biometric data of all people attending the event were extended and was extensive and was involving even people without any link to a crime, or without any reasonable suspect, or without any link to a concrete and factual threat. It is a sort of what is called preemptive surveillance. So without any doubt, any reasonable idea of a possible crime. And also because the watch list, so the database of images, include not only people wanted or person escaped from lawful custody or people already convicted for a crime, but also merely suspected of having committed a crime, or persons of possible interest. And this is written in the Code of Conduct of the Police of the South Wales, which is the only regulation of the system. And so the risk here is that we can create a form of surveillance which can ultimately affect also freedom of expression and freedom of assembly, considering that all people attending events can be subject to control, which per se represent an intrusion in the private sphere. And here the judges did not consider also the data minimization principles, so the fact that we should limit as much as possible the use of data, and moreover the use of very sensitive and delicate data such as biometric data, which are unique in the very sense of the word. So here also, if we compare this decision to the ECJ case law, for example, on data retention, we can see that the European judges consider that, for example, the storage of communication data, so data less intrusive than biometric data, in a generalized and indiscriminate way, was not proportionate, if not linked with a suspect of a crime. So here we can see a sort of difference from the perspective and the position of the UK judges and the European Court of Justice case law. So for sure, this will not be the last judgment on this topic, and it will be very interesting to see future developments. Going to the second example, so the use of facial recognition technologies for verification purposes. So in order to uniquely assess a user's identity and to create also a digital identity of citizen that allow them to access to fundamental social services and public services, this use is at the state of the art, as I said before, rather unexplored, and its consequences on fundamental rights are not profoundly studied yet. Even if we already have some examples of these technologies used in the European Union, for example, in France and in Ireland. And in France, we have the so-called ALICEM app, which is an app promoted by the French government and approved with a decree, and allows the creation of a digital identity of citizens using facial recognition technology in order to compare a short video that citizens have to take in order to have access to and to use the app with the images that are included in the electronic passport, which is mandatory in France. And this kind of technology has been challenged by an NGO, La Quadrature du Net, before the Conseil d'État, and the case is still pending. But what the claimant affirmed and contested about this app is the fact that, first of all, it is based on the consent of users. But here we can question if it is a real free consent in the sense explained in the GDPR, because here the use of facial recognition technology and the biometric data are the only way to have access to this app and to use it in order to have access to fundamental public services. So there is no alternative other than the use of the trade somehow of our biometric data. Secondly, because it is an app and the use of facial recognition is also considered disproportionate, and the claimant are questioning if the state could adopt seemingly effective but less intrusive instruments to reach the same aim. And the other point is the fact that there is a lack of transparency, because we do not know exactly how the algorithms work, and also what are the use of biometric data collected by the app, meaning if they are retained or not, and how they are used, and who is responsible for the control of the app itself. And another example of the use of this kind of facial recognition systems is the controversial public services card program used by the Irish Department of Social Protection, which also drew the attention of the UN Special Rapporteur on Extreme Poverty and Human Rights recently, because the card is the only way to have access to some social protection systems and services, such as welfare services, but also citizenship application or student grant applications. And it requires a facial image as a part of the registration process. And then the department stored this image in a great database run by the department itself. And then the facial recognition technology compare all the images stored in this database in order to detect cases of identity theft or double claiming of benefits. And so in this way, also welfare frauds. And in these two examples, so the French and the Irish ones, here the balance is between the effectiveness of public services, the correct allocation of resources, the cost-saving needs on the one hand. And on the other hand, not only privacy and data protection, but also somehow social rights, because the facial recognition technology is able to deny access to fundamental services. And data breaches or misfunctionings or errors that are that are also proved by the scientific community, if not properly corrected by safeguards and alternative systems, could ultimately lead to affect the possibility to enjoy social services. And if we think also about digital divide, as I told before, which has strongly emerged also during this pandemic, the digitalization and the mandatory requirement of a digital identity based on facial recognition technology could exacerbate social differences and inequalities by making it difficult for poor and already disadvantaged categories of the population to have access to basic services, as underlined by the UN rapporteur. And in all these examples, citizens who want to have access to fundamental services are obliged by public authorities to renounce to their biometric data and to submit them in favor of the functioning of facial recognition systems, somehow requiring people to trade this biometric data to have access to essential services which they are already legally entitled to. So what clearly emerges in my opinion about all these examples is the fact that facial recognition imposes to consider multiple legal challenges according to the kind of use facial recognition technologies are developed for. So we have different balance to consider if we have the example of the Cardiff court or the last one that I mentioned. The use of this sophisticated technology using collecting, retaining, and processing our biometric data raises more and more concern in civil society, and I think that the academic world should seriously rethink on the opportunity of such technologies, and as the High Court said, to keep pace with emerging technologies. And I think that the most significant problem here is also the failure to apply what some scholars call the policy before technology approach. So the trend here is to use facial recognition system without proper rules. I mean, here in Europe, we have the GDPR for sure, but the GDPR doesn't cover all the peculiarities of this kind of technologies. So I think that in all these cases emerges the need for a more comprehensive regulation of this specific technology to establish a set of safeguards and rules, also based on a clear understanding of the functioning of this technology, and thus implying a profound knowledge and also a dialogue with data scientists and private companies creating this kind of technologies. And this clear understanding could lead to a correct prior assessment of the rights implied and also of the risks. And the regulation and discussion of the limits of the use of these delicate technologies cannot always be attributed, as often happen, to a subsequent intervention of judges and courts. And if I agree with what Solov, in one of his most famous work on privacy, calls the false trade-off between privacy and security, and what also Giovanni said before, the false trade-off somehow between technology and fundamental rights, I think that there is the need for a careful regulation, which is the only way to avoid dramatic risks linked to these rapidly evolving systems, of which facial recognition is a perfect example. The danger is the creation of what some authors called an ubiquitous data variance, and that affects not only privacy and data protection, but as I said before with the French and Irish examples, also other fundamental rights and ultimately the functioning of democracy itself. If we see privacy as the European Court of Justice said in its case law, but also the European Court of Human Rights, If we see privacy as a core value of a pluralist society, it is easy to understand how these rights can be seen as a cornerstone for the enjoyment of other fundamental rights, such as Giovanni also said before, freedom of expression, but also freedom of assembly, and the principle of transparency, the relationship between citizen and state, as my colleague said before, and also the enjoyment of social rights and also equality and non-discrimination. So, concluding my presentation, what I want to underline is the fact that, for example, a Microsoft researcher, Luke Stark, affirmed that facial recognition is the plutonium of artificial intelligence, describing it as dangerous and racializing. And also some cities in the US recently decided not to ban facial recognition systems in their cities. And also private companies just a few weeks ago, for example, IBM, so quite a big tech company, publicly declared that they would not use or implement this kind of technology anymore, and I consider these examples as the clear sign that also the private sector, which has an economic interest in developing this kind of technology, perceive this system as a real threat, demanding for a stronger legislative intervention. And so I think that this is the biggest challenge that we as lawyers have to face. Thank you.
Thank you so much, Giulia. You underline a very dystopic, maybe future also for us, and we have to discuss great topic. Okay, right now, questions? I haven't seen any raise hand. There's someone at the moment. Professor Zenozenkovic? No. Okay.
No, okay. Just to point out, I always, this is something I always repeat. It is useful in these cases to see what have been the reactions, the European reactions, when after 9/11 the Patriot Act was introduced in the US, and what we have done after the Bataclan and Brussels terrorist attacks, and just shows that the reaction of states are substantially the same. I mean, admittedly, well, we don't have somehow we don't have the same kind of control. I mean, the intervention of the National Security Agency under the Patriot Act is much more invasive. But if you look at the tradition of the rule of law in continental Europe, I mean, I think this is an aspect that you should somehow highlight in comparing. I mean, there's the declamation, you say, oh, but the Americans have gone way out of sort of what should be expected in a democratic state. And then when our institutions are attacked, when our public peace and our security is attacked, we behave exactly in the same way. And facial recognition is one of those unfortunately poisonous fruits of the terrorist season in Europe. Just to point out that there's declamation and then there are facts, and so we don't sort of we in Europe at least I don't think we're very those critiques we did to the US were not very legitimate, also considering that the US is sort of a superpower and Europe is not a superpower.
Thank you.
Thank you. Richard Kay, please.
I was just thought in listening to Professor Zenkovic that the problems which were pointed out here call for some form of legislation, regulation. Complicated. It's not the use of this technology is not the same in different circumstances. And so it strikes me that the worst possible time to be working on this regulation is immediately in the aftermath of a national security breach. It's type of thing which the legislature should be working on now rather than when it becomes an urgent matter.
Yeah, I think that great attention to this topic.
Giulia, you have to speak louder.
Yeah, sorry. I think that also, for sure, the example of Professor Zenkovic are right, and I will take them into consideration. But connecting to what Professor Richard Kay was saying, also after the Snowden revelations, I think that the attention on privacy and data protection was raised, and also was more considered by civil society, by NGOs, and by understanding the risks. I think that the Snowden revelation, whether we can think about them, but underline the risks and about the use of this kind of technology, and in particular about retention and collection of data. So these are some interesting points.
Thank you, Giulia. Other questions, considerations? Okay, thank you, Giulia. Thank you, Giulia FORMICI. And now is the moment of Claudia MARCHESE from Università Suor Orsola Benincasa for Naples. The topic is new media and elections, which regulations. Claudia, the floor is for you.
Thank you very much, Professor Clementi, and I want to thank the organizer of this event for giving us the opportunity to expose our researches. Today I will talk about social media and election, and I wonder which regulation we can apply to this phenomenon, which regulation we can use. My researches generally focus upon political participation and right to vote, and now I'm trying to deepen my researches concerning technologies, social media, and election. So this is an ongoing research, and I will thank you for your suggestion. So,
sorry, Dr. Marchese, there's a very, I don't know if you, but there's
a noise
sound in your intervention, so we can't hear you very well. Maybe it's maybe the headphones, maybe, I don't know, but it's very disturbed. Whatever you're saying is very disturbed.
I will try to speak louder.
No, you should try and take your earphones off.
Okay,
and,
okay.
And use just a simple microphone.
Okay, I don't know if you managed to hear me.
Yes.
Or
this is better, right?
Now better. Thank you.
Better? Okay. Maybe I could try with another device, or I don't know if you have difficulties in listening, in hearing me. So I will start my presentation. As I have just said, the main topic of this presentation is the relation between social media and election, and in particular, I would like to deepen all those problems that are related with the formation of, with the free formation of the electoral will. So it's obvious that the internet and social media have increased the flow of information, including political comments. This situation has generated a sort of everlasting electoral campaign in which public and private subjects intervene. Most of all, social networks constitute a multiplier of information. As you know, they accelerate the spread of information thanks to the flow of news, pictures, videos, to the possibility to express reactions, to post or to share contents, for example. This flow of information during the electoral campaign is able to determine a series of serious danger for the free formation of the electoral will and for the democratic process itself. These risks are determined by various factors. For example, we could consider the effect of algorithms that select and propose news that reinforce the conviction of the user, or we could consider the manipulation of the algorithms to give a great visibility to specific posts. We have the transfer problems related to the transfer of user data, such as their political preferences to third parties. And finally, we have a very important issue that is related to the impact of fake news. It's clear that we cannot deepen all these topics in 20 minutes. I will try to offer a brief perspective upon some of these arguments. The interest involved in this, when we try to deepen this argument, are particularly delicate. On one hand, there is the guarantee of the freedom of expression, and on the other, the preservation of the possibility to conduct free and fair election, and the free formation of the electoral will. So, trying to schematize my presentation, I will try to briefly illustrate 3 points. The first one that is related to the micro-targeting and to the presentation of content that are based on the preferences shown by the user of online platform. The second point that is related to the diffusion of viral posts that have gained visibility, for example, through the intervention of trolls, fake profiles, or both, and that can influence the formation of the electoral will. And finally, the third point is related to fake news and to the regulation that we can apply during the electoral campaign. I will try to refer to specific regulation when they have been approved or they are present. It's obvious that when we talk about the electoral campaign and social media, we cannot apply automatically traditional regulation concerning, for example, radio or television or traditional media. This is the case, for example, in Italy of the law number 28 of 2000. And this approach has been confirmed, for example, by the guideline adopted on the 1st February 2018 by the technical table for the guarantee of the pluralism and of the correct information on the online platform in Italy. So we have to consider and we have to wonder if specific regulation exists. And for example, when we talk about election and social media, we could refer in France or in Spain to the regulation that have extended to social media the possibility to apply the rules concerning the electoral silence. Or, for example, in France, Spain, in the United Kingdom, we can note that they have established the obligation not to disseminate surveys or exit polls before the election. And furthermore, another example is France. We have specific transparency requirements on online platform in the 3 months preceding the election until the day of the scrutiny. So this is a general introduction upon this theme, upon this topic, and now we can move to examine the 3 different points. The first aspect to consider is related to media pluralism. So, as you know, online platforms propose specific content to users on the basis of the preference previously expressed. Consequently, the news and political advertising, for example, shown, tend to strengthen the personal conviction without expanding the perspective of the user. So we have a serious problem of polarization. With regard to this topic, to summarize, for example, we could suggest to complement the algorithm that select the content to be proposed to the user on the basis of their preferences with an algorithm that values the pluralism of information. This suggestion is obvious that has been also object of critics, for example, as for concern in the United States, the problem of the net neutrality doctrine. Another problematic aspect is related to the way in which specific posts and content go viral, thanks to the spread of information determined, as I have just said, by trolls, fake profiles, both, that intervene in the diffusion of information, so amplifying their effect. And it's clear that this impact happened concerning the effect of specific information can be relevant during the period preceding the election. This kind of information is particularly dangerous for the electorate, and it could be even more dangerous when related to fake news. The combining of these phenomena could seriously distort the perception of the electorate and could alter the formation of the electoral will. It seems possible to maintain the risk of the affirmation of a sort of modulated democracy, as someone has said. With regard to the case of specific content that go viral through the intervention of fake profiles, trolls, bots, and other artificial systems, we could, for example, consider the importance of rules that introduce transparency clauses or disclosure clauses. These rules are really important. It's obvious that they impact sometimes upon the guarantee of the anonymity, but it could be relevant for the guarantee of the electoral will of the will of the electorate to analyze the source of the information. The guarantee of the anonymity, it's obvious that is a guarantee protected, for example, by the First Amendment, or a guarantee that has been expressly recognized by the Charter of Rights of Internet that has been approved in Italy in November 2015. But this guarantee, the anonymity, that could be really important to express to critics or to express a dissent against the majority or, for example, the government. We have to allow the introduction of limitation of this guarantee to even to protect democracy. Nowadays, the principle of anonymity used in the social media, for example, could risk to determine more danger than benefits for the democracy and for the electoral process. And we know that, for example, in the United States, they have allowed, the case law has allowed restriction to the guarantee of anonymity if we consider true leading cases that would seem to affirm opposing principle, but that can be combined. I could refer, for example, to the McIntyre versus Ohio Election Commission decision of the Supreme Court and Citizen United versus Federal Electoral Commission. This decision would seem to affirm opposing principle, considering that the decision McIntyre versus Ohio Election Commissions recognizes a strong protection of the right to anonymity, while the decision Citizen United versus Federal Electoral Commission affirms the predominance of the disclosure clauses. This contrast in reality is only apparent due to the fact that the principle of anonymity is always granted when the opinion expressed can be attributed to a single individual for private purposes. Conversely, it is possible to affirm a predominance of disclosure clauses in presence, for example, of corporate expenditure. A similar decision seems to be reasonable, and we could balance the different interests and situations that are involved. Transparency obligations are imposed also in France, for example, to grant the free formation of the electoral will. We could consider the law adopted in 2018. This law at the Article 4 establishes the obligation for the owner of the online platform to provide clear, honest, and transparent information upon the identity of the natural or legal person who pays a remuneration to the online platform in exchange for the promotion of certain information, for example, We could say that in France, online platforms have also the duty to render public the amount of money they receive. This data has to be inserted in a publicly accessible register. So we can note that with regard to this second point, one possible solution could be to attribute value to the transparency clauses and to disclosure clauses. So we could try to restrict in a certain way. Also, some guarantee has the right to anonymity until a certain point. It's obvious to grant the free formation of the electoral will, and there are differences if we consider the case in which an opinion has been expressed by a private individual, or if we have corporate expenditure that can influence the way in which the elections are conducted. So the third point is briefly related to the fake news. I would try in these few minutes to illustrate different kind of approaches, and this point is obviously related to the presentation of Giovanni De Gregorio and to the first presentation of Tommaso for certain aspects. We could consider that with regard to fake news, we have different approaches, and I have tried to consider briefly the United States approach, the regulation adopted in France concerning the election, the German case, with some elements concerning the Italian approach. It's obvious that a national exam is only a part of the question, and we have always to consider the international level, because we are dealing with a global problem, and sometimes we have had the intervention of foreign subject in national elections. So the exam of the national regulation is only a partial, it's only a single aspect of a bigger problem, of a bigger question. It's clear that when we talk about the United States approach to the fake news, we have to refer first of all to a leading case, that is the United States versus Alvarez, and examining this decision, it's clear that also fake news have had an indirect protection to grant the freedom of expression and the free speech. And the main idea at the basis is that when it's possible, false speech, false ideas have to compete with all the other ideas, so that in order that finally the truth can win. But this main idea can find restriction when there is a relevant public interest, and in the case of the election, it's clear that there is a relevant interest to protect the integrity of the electoral process. But in the case of restrictions adopted with regard to the freedom of expression, there is a strict scrutiny, so that the introduction of restriction became really difficult. So, considering these difficulties to adopt directly regulation that restricts the freedom of expression, above all concerning the political speech, that is one of the main aspects of this freedom, it's clear that we have an intervention of private subjects, and private subjects that have been solicited by the Congress, for example, to adopt code of conduct or self-regulation. So we have an important role that have acquired social media, and this part exactly is related to the presentation of Giovanni. Another point that I would briefly consider, and that it is related to the previous presentation, is that is the section 230 of the Communication Decency Act that establishes an exemption of liability for internet providers and users. It's clear that we have a wide guarantee of the freedom of expression, and that we have an approach that maximizes the role of social media and self-regulation and code of conduct. A similar approach that encourages the role of social media and self-regulation can be found in the resolution adopted the past year by the Italian's Communication Authority on occasion of the European election held in May 2019. For example, in this regulation, we can read that as part of technical table for the guarantee of pluralism and correctness of the information on digital platform, every useful initiative is taken to promote the shared adoption of measures to combat disinformation and damage to online pluralism. The authority promotes through self-regulation procedure the adoption of measures aimed at contrasting the dissemination on the networks, and in particular social media, of contents in violation of the principle devoted to protect the pluralism of the information and transparency of the news. So we find another times a reference to self-regulation procedure. We have a stronger, a deeper approach in France concerning the electoral campaign if we examine the rules introduced in 2018. La loi 22 décembre 2018 relative à la lutte contre la manipulation de l'information. In particular, the Article 4 of this law establishes that in the 3 months preceding the election and up to the day of the scrutiny, in the event of false allegation or attribution likely to alter the freedom of voting and disseminated in a voluntary, artificial, or automatic manner through an online communication services, the judge, at the request of the public prosecutor of a candidate or a party or a political group or anyone who has an interest in acting, may require any natural or legal person to take all proportional and necessary measures to stop the dissemination. The entire Title 3 of this law is dedicated to the duty of cooperation of operators of online platforms in the fight against the dissemination of false information. Furthermore, providers are required to make tools available to users to allow them to report false information. Internet providers must also guarantee a series of complementary measures such as, for example, transparency of the algorithms, fighting against the massive propaganda of fake information, transparency in relation of the source of the news, and any remuneration for the promotion of information. So we could note that this regulation adopted in France is a really specific regulation, and it's mainly based upon transparency rules, and this could be a valid approach, a specific approach that has been, I will conclude into 2 minutes. I will summarize that finally the last point, the final point was about the German regulation that is really specific in the fight against fake news, with a duty of the service provider to remove illegal content in a very short period of time. We could note, trying to summarize 3 different approaches. The first approach that is mainly based on code of conduct and self-regulation, and that is based upon the intervention of social media and provider. And the second kind of approach that is based on transparency rules, that in my opinion is a really valid approach. And the third approach that is based upon duty to remove illegal content or fake news, and upon the introduction of specific sanctions and liability. That is a really restrictive approach, and an approach that could be easily instrumentalized in specific countries. I think that a middle way could be, that is, in my opinion, the French way could be a good approach to combine the intervention of public subject, private subject, with the responsibility of the user and the provider of the online platform. I don't know if I have concluded the minutes.
Time is finished, I'm sorry.
Okay, thank you very much.
But it's very clear, Claudia, what you said, and very, very interesting also for the points that at the end of your presentation we have outlined. Okay, now we have time to questions or considerations about the paper presented by Claudia Marchese. I don't see any raised hand. If I may, waiting the rest of the colleagues, I can ask you, Claudia, regarding the self-regulation of Twitter and Facebook, especially regarding the recent interpretation of Twitter and Facebook on the presidential electoral campaign, pointing out down of the presidential tweet something to explain to the world that you can use you can manage the information, and you have to try to fix some different probably things more than that the things are written in the tweet. So my question is for you regarding the self-regulation. The first topic is what you think, or do you think that the self-regulation, the recent self-regulation of Twitter and Facebook in the presidential electoral campaign will change the perspective also in the future, also for the public sector, for the public regulator, like an instrument to give some more details to do something more specific or more regulations, public regulation. And second, and the second question is if this instruments that Twitter and Facebook pointed out recently are also a sort of a shield for them to express other opinions in a sort of, I would say, challenging battle between a position of the president in a polarization electoral campaign, in a polarized electoral campaign against the new media. So in a sort of a different battles in the cloud of the social networks between the president as an example of an old expression of the old medias, and the new medias as an instrument to give the opportunity for all the persons, for all the connected on their social media, to understand how is important the use of the social media, especially in the politics and especially during the electoral campaign.
Okay.
And let me check if there is someone. Professor K, Professor Caffardi, Soma, no one?
Let me say something, if you don't mind, to what Professor Clementi just said. The problems of regulating speech and election context, Ms. Marchese has outlined. As you know, Professor Clementi, the social media, and something we just talked about actually in the previous sessions, the organizers and the owners of the social media exercise some regulatory power, and again, very famously, they have done so with the president's tweets, and another one just yesterday. you know, whereas we might be worried about the kind of control that these agencies, these private institutions work on the ability to express oneself, in a way that strikes me as fortunate that they can be a counterweight to the radically libertarian constitutional law, which we have found ourselves with in the United States, where pretty much unique in the world, I think, where pretty much anything goes. So whereas we are worried about the intrusion into public regulation of private entities, in this case, we may be grateful for them. And it's another example of what we talked about before, between finally public and private spheres are dissolving into each other.
No, very interesting. Also, they are at the end, at the moment, sort of a counterpower, no?
Yeah.
In the absence of regulations. Very, very interesting. I'm agreeing with you, Professor K. Okay, someone more? Any more? Okay, Claudia, the Zoom floor is yours.
Thank you very much, and thank you for your suggestion and questions. So, as for the...
Please louder, Claudia.
Okay. As for the regulation and the intervention of social media in politics and concerning the self-regulation adopted by this subject, I think that I'm not convinced to attribute the main role in the governing of the information, in the governance of the freedom of expression to this subject. I think that an intervention of the public regulator is also important. It's really difficult when we talk about social media, but it's really important. And in all the cases that we have considered, it's obvious that we have a central role of social media if we consider self-regulation, or if we consider the respect of transparency rules, or finally, if we consider the duty, the introduction of the duty to remove specific content. But it's really important to examine with a new perspective these themes, and also, in my opinion, to adopt specific rules, specific regulation, considering all the new problems that are imposed, that emerge on the basis of these new social media. It's clear that in the United States or in America, if we examine the resolution, the communication of the European Commission, the last one, there is a central role of these of social media and self-regulation, but it's important to establish at legislative level, in my opinion, transparency rules, and also sometimes limitation restriction to, for example, anonymity and so on. It's clear that it's difficult to balance the different rights and freedoms that are involved in this process, but we have a very relevant interest, that is that we want to guarantee the free and fair elections.
Thank you so much, Claudia. Also, because your considerations are very useful. Also, to say that we have, I would say, for the colleagues from the other side of the ocean, that we have a fantastic rule in Italy that in the day before the vote, we do not use any instruments to maximize the political consensus. And it's so funny because we don't have any sort of a great regulation about the social networks in that day. So normally, I have seen also in Italy that we have a sort of regulation, but you know, probably also you have seen in the electoral campaign in US at each levels, that in that day, the date of the vote, you can promote yourself to reach the last but not the least consensus. So it's a political consensus. So it's very interesting also this point, the Claudia Marchese, of your presentation, because it's useful also to stress that the day before the vote or the day of the vote is a special day, the day of democracy. And when the day of democracy begins, it's important that all candidates are shut up. If you have someone who during the day of the vote says something, maybe can alterate, can corrupt the political process. Also considering that the day of the vote until now is, I would say, not so much the election day, not because also the concept of the election day is changing. No, for instance, if you think regarding the postal vote or the vote from distance, is the same. So we are changing also these topics in the ideas of regulating the electoral campaigns throughout the new technologies, throughout the social media, and so on and so on. Thank you. Sorry for my because I consumed time, and we have a wonderful presentation now from Davide ZECCA from the University of Pavia. Davide, you are with us? Yes.
Yeah.
Yes. Okay. The topic is secrecy of communications and use of spywares. How to reconcile individual rights and collective security concepts. Davide, the floor, the Zoom floor, it's yours.
Thank you very much. So first of all, let me, I hope you can hear me well. Let me start by thanking the Associazione Italiana di Diritto Comparato and the Young Comparative Committee of the American Society of Comparative Law for rescheduling the conference online, because this has also allowed all of us to listen to many more panels that we would have otherwise been able to. And so this is a great satisfaction and a great chance for all of us. And thank you also, Professor Clementi, for moderating and chairing this session. So let me start by an empirical consideration. So communication among humans used to happen by voice or materially by basically paper. But in recent years, we have seen a great and an increasing transition towards digital and dematerialized communication. And while this is inherently a great chance for empowering the possibility to communicate from all over the world, it brings also about a number of challenges for lawyers and for constitutional lawyers, and a number of threats. And especially I'm referring in this short presentation with the threats associated with online investigations carried out by public powers, and therefore to all the issues that are connected to criminal proceedings. So online investigations or investigations of digital communications may happen either traditionally, so we would have the wiretap of telecommunications, or may happen through the internet with a number of softwares that are explicitly designed for that purpose, either by governments or by private companies that then sell these softwares to governments. And the idea of spyware is that basically you inoculate from afar, so from remote, a software on the device that is used by a user, and you have access to that device. Actually, there is also a limited number of instances in which the inoculation happens by contact. So it's an hardware inoculation, and it is as it used to be when you wanted to wiretap someone, let's say, in the near past. Or it may happen through the internet. So basically, you send, the public prosecuting authority send either an email or a link through the so-called technique of phishing, and once the link is opened, then the spyware, the program, automatically installs on the computer or the smartphone or the tablet of the target subject. Consider also that this is what happens most of the times, but public authorities are also able to install so-called black boxes onto the servers of internet service providers, and therefore they do not really have to inoculate them onto the devices of private individuals. So there are two main ways of conducting online investigations. So there is online search, which basically is you enter onto the device and you just make a copy of what is on the device. Or there is online surveillance, or as they call it in Germany, online Durchsuchung, which means that basically you take control of the system of the smartphone, and then you are able to manage and open all the peripheral devices, which are, for example, the microphone or the camera, and so on and so forth. So this means that basically you have what the lawyers that have been dealing with this subject call a Trojan. So this, of course, is inspired by the Trojan horse of Ulysses in the Homer Iliad. So my intention today in this brief presentation is to try to give an account of some of the reactions that a limited number of legal systems have put in place to face the challenges brought about by the use of spywares and by online investigations in general. So the three legal systems that I've chosen, which of course are a limited sample size, but I hope that is nonetheless sufficiently significant for the discussion, are first Germany, which has been one of the first legal systems that has dealt with these issues straightforwardly, because there have been two decisions by the Federal Constitutional Court of Germany concerning the use of spyware and online investigations. Then the United States of America, where spywares have been used from around or for around a couple of decades, but there is no, not that much of a body of decisions in this regard, especially there is no decision with specific regard to spywares by the Supreme Court, although there is a decision by the Sixth Circuit of Appeal, which has not yet been reversed by others. And finally, the case of Italy, especially because I think that all of the Italian people in the audience know that we've grown accustomed to the use of spywares and Trojans because of the famous Palamara case, which is out onto newspapers every day, and all the issues that are associated with it. So let me start with the case of Germany. So in Germany, what happened was that first a public prosecutor was asking in the at the half of the first decade of the 2000 to a judge to basically carry out a wiretapping through the installation, the inoculation of a Trojan. And the request was rejected because there was no specific legislation granting judges and public authorities the power to carry out investigations with that technical tool. So what happened was that in 2006, the land of North Rhine-Westphalia basically amended its law on the protection of the Constitution to allow a government agency, a state agency of that specific land, to carry out online surveillance. And what followed was that the law was basically brought before the Federal Constitutional Tribunal in Karlsruhe, and the judges in Karlsruhe handed down a long and very detailed decision on the issue, which basically was the foundation of a new right, which was the right to the integrity and confidentiality of information technology systems. How did they end up doing that? Well, basically, they built their reasoning on Article 2.1 and Article 1.1 of the Grundgesetz, so basically the human dignity and the right to personality, and they underlined that the use of online investigations and online surveillance was not forbidden and could be balanced with other interests. So the limitation of the privacy and the secrecy of correspondence of citizens could be weighed in and balanced with collective security concerns, but this should basically be done in a certain manner, and so the analytical nature of the judgment. So first, the limitation of those rights and the possibility to resort to those instruments should be very precise, and so there could be no reference to other provisions of law. So basically, this is the principle of determinateness or precision in criminal procedure law. Secondly, the assessment of the German Federal Constitutional Tribunal carried out a scrutiny on the appropriateness or the proportionality of the measures, and said that since the intrusion or the interference with the right to personality and the right to privacy and the secrecy of correspondence was so intense, if we were to use a spyware, then it could be used only for those overarching legal interests, such as for the protection of life or the liberty of people. And by doing so, it also held that there should be enough evidence that the people that were targeted by those investigation instruments were actually involved in conducts that were threatening those legal interests, not just terrorist activities. So this was not a limitation ex materia, but a limitation on the basically the protected legal values. And also the tribunal in Karlsruhe underlined the risks that are associated with the use of spywares for two reasons. First, when you install a spyware onto a device, you are not just able to wiretap the future communications, but you can access the storage capacity of the device, and therefore by doing so you can track down and build a very extensive profile of the subject, which of course is way beyond what is needed for a criminal investigation. And secondly, consider also that whenever we're talking about correspondence and communication, there are two people at least involved in communication. There is the one that is carrying out the communication, and there is the one that is communicating with him. And so you are basically infringing on the right to privacy and the secrecy of communication of these other subjects. So this was basically a very analytical judgment, and what followed was that a federal statute was approved in Germany, and this federal statute, which once again enabled the Federal Criminal Office to carry out investigations for the use of spywares, was brought before the court in Karlsruhe. This was actually in 2016, and the scrutiny once again was on proportionality, and the outcome was very similar, and the only thing was that basically the German Federal Constitutional Court said that different types of investigations should need or require different thresholds. And so you, according to the interference of the instrument that you use, then you're supposed also to require a different threshold of evidence of the probability of the criminal conduct taking place. So in the interest of time, let me switch to the second case, which is the case of the United States of America, where actually the use of keylogger softwares or spywares was already in place in the early 2000s, and I'm referring first to the so-called Scarfo case, in which it was held that the use of a keylogger system, so a pen register, which means that basically you gather from the device that is used by the user the identity of those that are communicated with him, so let's just say the email address and the frequency of the contacts, but you are not infringing on the content, so you just know that he is communicating with those subjects on a regular basis. Was not a general warrant, and therefore was authorized, was not prohibited under the Fourth Amendment. And later on in the Alba Forrester case, basically the use of keylogger and the transmission of this information to public authorities was found not to infringe on the reasonable expectation of privacy that subjects have, because basically the metadata that you transmit to the internet service provider are considered as falling within the so-called third-party exception, which in American privacy law means that basically all the information that you hand to third parties, for example, the bank or also the internet service provider and your IP address, are no longer protected by the Fourth Amendment guarantees, because you are renouncing your privacy on that. And so there is a very strong association with the secrecy of the information and the privacy of it. What has actually happened in the United States is that the FBI actually created itself a number of spyware, which I have unfortunately not the time to go through, but the Supreme Court has not yet considered the use of spywares. But as I was telling you before, or let me just rephrase, there has been first a decision by the Sixth Circuit of Appeals in 2010, which considered that the third-party exception did not apply to the content of communications, because basically, in this case, there were emails that were the content of emails was requested by a governmental authority to the internet service provider, which stored all the information and then gave it to the government without a warrant, because there was a statute, the Stored Communication Act, that allowed this to happen. But actually, the holding by the Sixth Court of Appeals was that this content, the content of emails, was protected. And so there was, let's say, a cleavage between the metadata, and so the IP address, which courts in the United States have held that is not protected by a reasonable expectation of privacy, such as the case of those that are basically tracked down for watching child pornography on the internet, and instead the content of emails. Then there could be some things that could be said concerning basically the let's say not so consistent case law of the US Supreme Court concerning privacy, because there have been some changes recently. The paramount case was the Katz case dating back to 1967, and the reasonable expectation of privacy that basically marked a step further from the understanding of privacy as linked to property rights. But then, for example, in 2012, in the Jones case, the court led by Scalia again went back to an understanding of privacy that was linked to property rights. Unfortunately, I think I don't have that much time left, so maybe I can turn to the Italian case. So what happened in Italy is basically that there has been, let's say, a little bit of a debate in the judiciary, because the intervention by the legislature, the lawmakers in Italy, has only been exposed afterwards, and still is not really into force, and I will say why in a few minutes. So in Italy, the first instance in which the court, yes, 5 minutes, thank you.
So
5 minutes? Okay. Okay, thank you. So the first case was the Viruso case, which was decided in 2009 by the fifth section of the Criminal Cassation Court. And basically, the spyware was used in that case not for retrieving from the device communications, but just for basically retrieving files that were onto the device. And so what happened was that the court found that there was neither a violation of the domicile, nor a violation of the secrecy of correspondence, and spywares could be resorted to as an atypical piece of evidence, which in the Italian criminal procedure system are allowed, because not all pieces of evidence have to be codified in the criminal procedure code. What happened afterwards was that in 2015, another section of the Criminal Court of Cassation said something different, and with specific reference with the activation of microphones by using a spyware from remote. What was said was that this was a violation of Article 15 of the Constitution protecting the secrecy of correspondence, unless the warrant that allowed to carry out the investigation contained a specific indication of the places where the wiretapping through the spyware was taking place. This was because in Musumeci, the sixth section of the Criminal Cassation basically held that spyware are just another type of environmental wiretapping. So wiretapping among people that are present, which is actually a typical piece of evidence, a typical category of evidence. However, and this brings me towards the end of my speech, the following year, the Sezioni Unite, so the highest basically composition, or the most important composition of the criminal cassation court in Italy, in the decision on the Scurato case, found differently and said that the sixth session in the Musumeci case had basically erred in finding that all environmental wiretapping needs a warrant that precisely set out the places where environmental wiretapping must take place. The Sezioni Unite held that this is not true, and this is true only in the case the wiretapping is supposed to take place also in places of private residence. And however, we should also consider that there is an exception which in the Italian system basically gives birth to a twofold guarantee. And I mean that for all citizens, if you want to wiretap their conversation also with a spyware within their places of private residence, then you need a warrant that specifies the places of private residence, but also you need basically what over the Atlantic would call probable cause for wiretapping them, the existence of very strong pieces of evidence in that sense. Instead, this is not true for organized crime. And you can wiretap also through the use of, yes, thank you, through the use of spywares. You can wiretap into the domicile of people that are investigated for crimes of organized crime or associated crimes, and this would not, in the interpretation of the Criminal Cassation Court, infringe on the constitutional rights of the target subject. So just to wrap up, the presentation was aimed at first highlighting the risks that underlie the use of online investigation techniques, and to show that while there have been different approaches, in Germany, for example, there has been an intervention of the legislator, while elsewhere there has been just an intervention of the judiciary, and in Italy there has been an intervention of the legislator, but just after the judiciary, and is not still in place because there have been several postponement of the entrance into force of some provisions of the legislative decree Orlando. There is a need to try to understand where the balance stands between the issues of preventing and prosecuting also crimes that are increasingly carried out online, and on the other hand, to protect the secrecy of correspondence and the privacy of people, which basically develop their personality more and more through those devices. And if we are not able to find a balance, that probably we are just leaving the courts to decide with a limited set of tools and constitutional principles. Thank you.
Thank you, Davide ZECCA, for your very interesting presentation regarding a very specific and really interesting topic. Okay, right now we have also a short time to questions, considerations. Professor Somma, I've seen correctly. Alessandro.
Yes, thank you, if I may. You mentioned this idea of finding out a balance between individual rights and overarching legal interests. I would say, is it really possible to find this balance from a general point of view, or one has to, I mean, from a general point of view, meaning by that involving international law or international standards, or one has also to consider the context, the type of criminality. We have countries with a high rate of criminality, countries with a low rate of criminality. We have organized crime. We have countries where the organized crime is really challenging the state. So I would say we probably have to consider the context and allowing compression of individual rights in case where criminality is challenging the state. I agree with those who would reply, okay, but individual rights shouldn't be compressed concerning the context where they are at stake. But anyway, do you agree or not that somehow the context must be taken in consideration?
Thank you, Alessandro. Davide.
If I may answer, thank you, Professor Somma, for the remarks. Short answer, yes, I do. Elaborated answer, I think that also we should try to be aware that this kind of balancement and balancing should be made also on a case-by-case assessment, which actually is what the Federal Constitutional Tribunal in Germany does and says, because it is true that the criminal environment may be different in different countries. And of course, Italy has a long experience in fighting first terrorism in the 70s and then organized crime. And so I do think that we need to be aware that a limitation of rights, especially when we have substantive pieces of evidence, is something that we must expect. But it is interesting, still drawing from the German case, that while the court in Karlsruhe said that, okay, there is a case-by-case assessment, don't forget that at least in Germany, we have the Wesengehalt, we have basically a core of rights that we cannot renounce, that it would be against our own constitutional nature. So I do agree that context must be taken into consideration, but let's try, at least in my opinion, not to make too many steps on what could suddenly, what we could suddenly realize is a slippery slope.
Thank you, Davide. Thank you. Is there other questions? Considerations? Okay, before to go to give the floor to Antonia Baraggia for the rest of things regarding the organizations in the future of our webinar, let me say thank you really so much to all the panelists, to all the attendees, to Professor Richard Kay, and to other professors and colleagues to participate, and to Associazione Italiana di Diritto Comparato, to the American Society of Comparative Law, Young Comparative Committee, to ask me to try to manage this wonderful session. Very interesting, very interesting papers, and really thank you so much. Then I hope in the future it will be possible to participate again, and I hope so that will be possible, because now I give the floor to Antonia, and Antonia Baraggia will say something to us about the future. Thank you, Antonia. Please, I give you the floor.
Yes. So thank you, Professor Clementi, and thank you all the panelists and all the participants. I just want to remind you all about our last and final webinar to be held next Thursday, June 25th, from 6 p.m. to 8 p.m. Central European Time, and the topic will be comparative law après le déluge, and we will have Professor Zeno Zenkovic chairing the seminar, and then we will have Professor Richard Albert, Professor Giuseppe Franco Ferrari, Professor Richard Kay, Professor Elise Poilot, and Professor Matthias Sims. So I thank you all of you for having been with us today, and I hope to see you for our final webinar. Thank you, and good evening, or have a nice day in the case of our American attendees.
Thank you so much.
Thank you. Thank you very much.
Thursday. Thank you. We'll see Thursday, June 25th.
Yes.
Bye-bye.
Bye.
Thank you.
Bye.
Thank you. Bye.